Your Honour, may it please the Court, I am McDonald, initials AB, and I appear on behalf of the accused, Mr Otto Lowtower. The accused is being charged with one count of possessing an illegal drug pursuant to Section 9, Subsection 1 of the Queensland Drugs Misuse Act. The defence is seeking a pre-trial ruling in accordance with Section 590, capital AA, Subsection 2, Paragraph E of the Queensland Criminal Code. Your Honour, I respectfully submit that the Court, pursuant to its powers under Section 130 of the Queensland Evidence Act, should find that the evidence against my client was obtained illegally and should be excluded on public policy grounds, of which brings me to tender my submission. On the 1st of June 2024, my client was driving when he was pulled over by Detective Senior Constable David Tarjan. Tarjan states that he made the stop in exercise of his power to carry out a licence check pursuant to Section 60 of the Queensland Police Powers and Responsibility Act, referred to as the Act from here on. In acting in his power, Tarjan, relying on Section 60 of the Act, where he was doing so not to enforce traffic laws, but to investigate drug offences. Tarjan did not form the requisite reasonable suspicion before interception. The interception was unlawful, and where the police searched the motor vehicle in exercise of powers under Section 31 of the Act, the police located drugs and items from the motor vehicle that they believed connected my client to the declared criminal organisation listed in the Queensland Criminal Code Criminal Organisation Regulation. It is my submission that the evidence found during the exercise of Section 60 and 31 of the Act be excluded, as there is no reasonable grounds for exercising Section 60 or 31 of the Act. My client maintains that he has not been associated with or a part of the organisation. On the night, Tarjan relied on Section 60 of the Act to intercept and stop the accused's car. Section 60, subsection 3, paragraph A and B, identify the enforcement of all traffic law as a purpose for which power created by Section 60, subsection 1 may be exercised. The purpose is to ascertain whether the driver is licensed. This was said to be the purpose which justified the police officers directing the accused to stop his car. The search of the vehicle was made in reliance on powers bestowed by Section 31 of the Act. Section 31 refers to a police officer who reasonably suspects certain things. The term is defined in the Act as reasonably suspects means on grounds that are reasonable in the circumstances. Under the circumstance, Tarjan's interception of the car was unlawful because the power vested by Section 60 of the Act was misused. The real purpose of the intersection was submitted to not be to enforce the Transport Act, but to determine whether an unlawful drug was in the vehicle. Resort was made by the police to Section 60 to avoid the legislative precaution to the exercise of the power of Section 31, namely the foundation of a reasonable suspicion that the unlawful drug was in the accused's car. I submit, Your Honour, that in the alternative, if the interception was lawful, the search of the car was not. Any suspicion of the presence of an unlawful drug in the car was not held on reasonable grounds that are reasonable in the circumstances. Tarjan relies on the fact that the accused is an alleged participant in a declared criminal organisation and that the Toyota was also connected to that organisation, information that was identified after the interception. As Tarjan states, he had no idea who the accused was when he made the interception. The interception and search of the car were corrupted by the illegality and are subject to the bunning and cross discretion. The Act must be read as a whole. Sections 31 and 60 of the Act have different purposes. Section 60 concerns traffic enforcement laws, and Section 31 and 32 are concerned with the detection of other criminal offences. The requirement of a police officer to form a reasonable suspicion is the precaution upon the power of Section 31. On the construction of the Act, where the purpose of the police officer's decision to stop a vehicle is the investigation of possible drug offences, the power is sourced in Section 31 and 32, not Section 60 of the Act. To avoid the defence provided in Section 31 by using the powers in Section 60 to investigate a drug offence is to misuse the power of Section 60 and reduce the interception of the car unlawful. The interception of the car was not sanctioned by Section 60 of the Act, as the purpose of the interception was not a prescribed purpose. The interception was not authorised by Section 31, as Tarjan had not formed the requisite reasonable suspicion. The interception was unlawful. Your Honour, here is where the bunning and cross discretion must be highlighted. The bunning and cross discretion have its roots in Crown against Ireland, where Chief Justice Barwick said, "Whether such unlawfulness or unfairness appears, the judge has a discretion to reject evidence. He must consider its exercise. In the exercise of it, the competing public requirement must be considered and weighed against each other. On the one hand, there is the public need to bring a conviction to those who commit criminal offences. On the other hand, there is the public interest in the protection of the individual from unlawful and unfair treatment. Convictions obtained at the aid of unlawful and unfair acts may be obtained at too high a price, hence the judicial discretion. Crown against Ireland was applied and explained in Bunning and Cross. Justices Stephen and Aiken identified considerations relevant when balancing the competing interest factors. In the recent case of Crown against King, the considerations were summarised as follows. 1. Was the unlawful act inadvertent? Or 2. Was it a deliberate flouting of the law? Or 3. Was the misconduct serious? And 4. Does the failure to comply with the law affect the cogency of the evidence? And 5. How serious is the offence charged? And 6. Are the powers of the police deliberately limited by the legislation to protect the public? The inference one can draw from the evidence is that the investigating possible drug offences, police should exercise powers under Section 60 of the Act in order to intercept motor vehicles rather than Section 31. This is to avoid the necessity to form a reasonable suspicion that drugs are in the vehicle, sought to be intercepted by the precondition for the right to stop it. The effect of such a direction is the power vested in Section 60 for the purposes of the investigation of traffic offences is being systematically misused to avoid the precautions which have been put in place in relation to the exercise of powers for the investigation of drug offences. It is in the public interest to condemn the conduct of police deliberately misusing statutorily vested powers. It is my view, Your Honour, that consideration outweighs the interest of the public seeing the accused prosecuted for what is obviously a serious offence. The evidence should be concluded. Thank you, Your Honour. That ends my submission.